Sorry, I was instructed wrong. I tried to get it right, sorry. Okay, we're going to ask each of you to do a 15-minute presentation, and because of the video conference, I'm going to ask you all to really stick to that time, otherwise it becomes really, really complicated technically. So, very welcome to our committee. I'm going to invite Mr. Drake to kick off the debate. You have the floor for 15 minutes.
Thank you to the European Parliament and the Civil Liberties, Justice and Home Affairs Committee for inviting me to speak before your critically important public hearings and the challenge you collectively face regarding the National Security Agency surveillance programs and their impact on your respective member countries, as well as the privacy of citizens in my country and yours. The fundamental issue before your committee is a foreign government, often in league with the intelligence apparatus of other countries, as well as cooperating internet, phone, and data service providers, spying on you and your citizens under the guise of protecting its own interests in the name of national security. A convenient constraint of monitoring control, especially conducted in secret outside the purview of law and public debate, while subverting your sovereignty.
Can I interrupt you just for 1 second? The interpreters ask you to slow down a little bit, otherwise they can't keep up.
I used to fly as a cryptolinguist on RC-135 reconnaissance aircraft in the greater European theater during the latter years of the Cold War. My primary target of interest was East Germany. The Stasi became monstrously efficient, using surveillance to enable their pathological need to know everything, their very operating motto. However, I never imagined that the U.S. would use the Stasi playbook as a template for its own state-sponsored surveillance regime and turning not only its own citizens into virtual persons of interest, but also millions of citizens in the rest of the world. Do we really want to become subject to and subjects of a secret surveillance state? In a surveillance state, everybody is suspicious, and laws protecting privacy and citizen sovereignty are regarded as inconvenient truths bypassed in the name of keeping the rest of us safe and secure as justification for the wanton and surreptitious bulk copy collection and unbridled access to vast amounts of data about our lives. Unfortunately, this surveillance regime has now grown into a globe-girdling system that has gone far beyond prosecuting terrorism and other international crimes and wrongdoing. Your committee faces the challenge of dealing with a secret, hidden shadow surveillance state, dissolving the very heart of freedom and liberty and our respective citizen rights, and using this power to expand sovereign free zones, even when it undermines the very fabric of society, breaks trust between nations, and endangers the very mechanisms we use for commerce and trade. This exceptionalism gives rise to an ends justifying the means mentality and violating the sovereignty of other nations and citizens far beyond the real threats we do face from those who would cause us real harm, but often exaggerating those very threats in public for access to all of our data behind the scenes. When national security services are more than willing to deliberately compromise the very information technology services and protocols that so many citizens, as well as commercial and private enterprises, rely upon and enjoy for legitimate confidentiality, data protection, and security in order to conduct their day-to-day business, it becomes very difficult to maintain trust in those systems. Nothing less than the very sovereignty of our citizens and states are at stake in the face of an unfettered surveillance state apparatus. From the recent disclosures of Edward Snowden, the U.S. government has routinely violated on a vast industrial scale the constitutional protections afforded its own citizens, while also disregarding the internal integrity of other states and the fundamental rights of non-U.S. citizens. I know, because I was eyewitness to the very foundations of a persistent surveillance state expanded in the deepest of secrecy right after 9/11. I was there at the beginning. While a senior official at the National Security Agency, I found out about the use of a top-secret domestic electronic eavesdropping program that collected and accessed vast amounts of digital data, including phone numbers, email addresses, financial transactions, and more, turning the U.S. into the equivalent of a foreign nation for the purposes of blanket dragnet surveillance and data mining, blatantly abandoning and unchaining itself from the Constitution and a 23-year legal regime enacted due to earlier violations of citizen rights by U.S. government's use and abuse of national instruments of power against Americans in the 60s and 70s. These secret surveillance programs were born during the first few critical weeks and months following 9/11 as a result of willful decisions made by the highest levels of the U.S. government. Such shortcuts and end runs were not necessary, as lawful alternatives existed that would have vastly improved U.S. intelligence capability with the best of American ingenuity and innovation while fundamentally protecting the privacy of citizens at the same time. I raised the gravest of concerns through internal channels, spoke directly with NSA Office of General Counsel, and then became a material witness and whistleblower for 2 9/11 congressional investigations in 2002, and then exposing massive fraud, waste, abuse, and mismanagement at NSA during a multi-year Department of Defense Office of Inspector General audit from 2003 to 2005 regarding a multi-billion-dollar NSA flagship intelligence collection program under development that was far more costly and far less effective in supporting critical intelligence requirements than a readily available and privacy-protecting alternative. I followed all the rules as a whistleblower until it fundamentally conflicted with my oath to uphold and defend the Constitution, and made a fateful choice in 2006 to exercise my First Amendment rights and went to the press with critical information about which the public had a right to know regarding the fraud, waste, and abuse, as well as the secret and unconstitutional surveillance programs. However, rather than address the illegality and wrongdoing, the government made me a target of a huge federal criminal leak investigation into the exposure of the secret surveillance programs and subjected me to severe retaliation, reprisal, and retribution that started with forcing me out from my job as a career public servant. I was subsequently blacklisted, no longer had a stream of income, while simultaneously incurring substantial attorney fees and other huge costs, necessitating a second mortgage on my house, the emptying of my bank accounts, including retirement and savings. And that was just the beginning. What I experienced as a whistleblower sends the most chilling of messages about what the government can, and I will emphasize, will do when one speaks truth to and of power, a direct form of political repression and censorship. And yet, once exposed, these unconstitutional detours were and still are predictably justified by often vague and undefined claims of national security, while aided and abetted by shameless fear-mongering on the part of the government. And yet, we are now in an era where sharing issues of significant concern in the public interest, which do not in any way compromise national security, are often now considered criminal acts of espionage aided and abetted by reporters and the press, yet anathema to a free, open, and democratic society. I did everything I could to defend the inalienable rights of all U.S. citizens and the sovereignty of the individual, which were so egregiously violated and abused by my own government when there was no reason to do so at all, except as an excuse to go to the proverbial dark side by exercising unaccountable, irresponsible, and off-the-books unilateral executive power in secret. I blew the whistle because I saw grave injustice, illegality, and wrongdoing occurring within the National Security Agency. I was subsequently placed under intense physical and electronic surveillance, raided by the FBI in 2007, and 2.5 years later, under the Obama administration, criminally charged under a 10-felony count indictment, including 5 under the Espionage Act, facing 35 years in prison. The extraordinary charges that were leveled against me by the U.S. Department of Justice are symptomatic of the rising power of the national security state since 9/11 and a direct assault on freedom of speech, thought, innovation, and privacy. The government found out everything they could about me and turned me into an enemy of the state. I became the first whistleblower prosecuted in the decade since Daniel Ellsberg under the draconian World War I era Espionage Act, a law meant to go after spies, not whistleblowers. Having the secret ability to collect and analyze data with few, if any, substantial constraints, especially on people, is seductively powerful, and when done without the person's permission and in secret against their will, is the ultimate form of control over others. When government surveillance of this magnitude hides behind the veil of secrecy, when it professes openness and transparency while practicing opaqueness and deceit, that's when citizens need to become very aware and wary of what the future might hold, when their very liberties are eroded and even taken away in the name of national security without their consent. The fear engendered through the invocation of threats, real and imagined, creates a climate where rights are ignored as a unifying cause for obsessing over national security and the use of fear by the government to control the public and private agenda. My criminal case is direct evidence of an out-of-control and off-the-books government that is increasingly alien to the Constitution and a democracy at home and abroad. The rise in this form of a contrary alien form of government, assuming the shape of a national security state under surveillance, evidences the all too distinct and historically familiar characteristics of an alarming soft tyranny and is an anathema to all forms of democracy. As Montesquieu wrote, quote, "No tyranny is more cruel than that which is practiced in the shadow of the law and with the trappings of justice. That is, one would drown the unfortunate by the very plank by which he would hope to be saved." One could make the case that the government chose to make me and others targets as part of a much broader campaign against whistleblowers in order to send the strongest possible message about what the government can and will do to suppress dissent and speech it doesn't like. And yet the United States' brutal and unrelenting crackdown on whistleblowers is outdone by the magnitude of what it is now trying to hide or continue as a result of the Snowden disclosures. NSA is not just eavesdropping on all Americans and building architecture for a police state in the U.S. It has created the largest set of mass surveillance programs in the history of the world, while covertly weakening internet security and privacy for everyone on the planet. Without privacy and robust data protections under the law, no real individual citizen sovereignty within a state and society is possible. NSA is doing this deliberately, systematically, and in secret. Even if we take NSA at its word, its intention to only target persons suspected of terrorism as it relates to foreign intelligence, they're clearly now collecting and storing as much of our communications as possible. NSA has inverted and perverted the heart of the democratic paradigm in which the government acts in public and our personal lives are private. Now everyone's personal and private lives and associated transaction and data history becomes the equivalent of secret government property, held for years as pre-crime data, just in case it is needed in the future. Secret dossiers of the state, while attempts to expose the government, are met with a heavy hand of criminal prosecution. The words of U.S. Senator Frank Church during the hearings he conducted on the abuses of national security in the 1970s are worthy of reminding us of what can happen when a state-sponsored surveillance regime is used as the excuse to keep us safe at the expense of liberty and freedom. If a dictator ever took charge in this country, the technological capacity that the intelligence community has given the government could enable it to impose total tyranny, and there would be no way to fight back because of the most careful effort to combine together in resistance to the government, no matter how privately it was done, is within the reach of government to know. Such is the capacity of technology. People in America and around the world should not have to worry about protecting themselves from an unhinged United States government, unchanged from its own constitution, but worry they must. And the government should not, under the guise of protecting its own citizenry, conduct mass dragnet surveillance in secret, let alone the rest of the entire world, while publicly crushing anyone who tries to expose it. I respectfully suggest that your committee duly examine the critical need of transparency and legal accountability to enforce fundamental and vitally precious citizen rights to speech and association, while protecting those who expose government malfeasance and wrongdoing, as well as providing for robust protections against unwarranted search and seizure by any foreign power, state surveillance agency, or corporate entity. I hope that your committee will consider a European Union-wide law that all EU-to-EU internet links and nodes must be encrypted with open-source encryption technology made available for the widest possible use wherever practical, while also audited by the EU. What we see now revealed on a global scale creates the power of mass surveillance and eludes effective control by current data and privacy protection regulations. How do your member states protect themselves from the predations of the surveillance regime? There's a distinct need for policies that prohibit third-party countries and commercial concerns from accessing and compromising personal data, while also covering vendors and suppliers of IT systems and products. There also needs to be put in place the power to prosecute and hold accountable those transnational companies and entities from secretly compromising the very infrastructure that society depends on for business and trade. PRISM proofing is your member state internet hosting and service providers is now critical, given how data is not so much broken as it is taken in rendition by the surveillance state. It is the constant possibility of the unequal gaze and reality of surveillance and observation, real or imagined.
Excuse me, Mr. Drake, the interpreters are asking you to slow down. And can I also ask you to come to a conclusion? Yeah. We have the video link waiting.
I fundamentally reject the dystopian premise given what happened to me. In conclusion, I was fortunate that I did not end up in an actual prison for coming out of the system and speaking truth to and of power, a dangerous act of civil disobedience and individuality for sure in these times. The last thing a free and open society needs is a digital fence around us, with the barbed wire of surveillance not only keeping track of our comings and goings, yet now increasingly wanting to know what we think and feel, the very essence of who we are and share as human beings. Thank you.
Thank you very much. Thank you very much for that statement. Now we have a video link with Mr. Wiebe, who's a former NSA senior analyst and who joins us from Washington. So very welcome. Can you hear us?
Good afternoon to Europe.
Hello. You hear us okay?
Mr. Aguilar, members of the Committee on Civil Liberties, Justice, and Home Affairs of the European Parliament. Greetings from Washington. It is true, constitutes the only true nonviolent protection for freedom-loving people everywhere. It saddens me deeply to say that here in the United States, certain individuals played important roles in changing the U.S. Constitution. While the Fourth Amendment demands that conditions of probable cause exist in order to demonstrate why a person's privacy rights should be violated, NSA slowly began to change the very meaning of that important language when the former director of NSA, Michael Hayden, stated that the operative language in the Fourth Amendment was not probable cause, but reasonable suspicion. Hayden made this distinction to free NSA from stringent prohibitions so that it could have a freer hand in judging what might be of intelligence interest in the wake of the tragic events of September 11th, 2001. The tentacles of NSA surveillance have been growing ever since, aided and abetted by a U.S. Congress, a Congress more eager to say yes in the name of national security than to perform its oversight duties in the name of the U.S. Constitution. Indeed, NSA's vague technical explanations only created further confusion, and Congress capitulated. When it was later revealed that the NSA was collecting information on Americans, NSA claimed the violation was accidental. However, we now know, thanks to Edward Snowden, that this assertion was patently false. When the news broke about NSA's invasion of privacy, two former and very highly respected directors of NSA, retired Army General William Odom and retired Vice Admiral Bobby Inman, commented sharply on the matter. and I both quote and paraphrase from the relevant news article. Should have been court-martialed was the judgment of the late General Bill Odom about Hayden. And President Bush should be impeached, added Odom with equal fury. Odom ruled out discussing the warrantless eavesdropping that had been revealed by the New York Times just a few weeks earlier. In a memorandum about the conversation, the reporter, Mr. Kenny, opined that Odom appeared so angry that he realized that if he started discussing the still classified issue, he would not be able to control himself. Why was General Odom so angry? Because he, like all uniformed officers of the military, took an oath to protect and defend the Constitution of the United States against all enemies, foreign and domestic. Because he took that oath seriously, and because as the head of the National Security Agency, he did his best to ensure that all employees strictly observed NSA's first commandment, thou shalt not eavesdrop on Americans without a court warrant. Also disappointed was former NSA Director Admiral Bobby Ray Inman, who was one of the country's most highly respected senior managers of intelligence and an author of the Foreign Intelligence Surveillance Act of 1978. Inman took strong issue with Hayden's disregard of the law. And I quote, "There clearly was a line in the law which says you couldn't do this," said Inman. "You can't do anything that is not authorized." Inman spoke proudly of the earlier ethos at NSA, where it was deeply ingrained that you operate within the law, and you get the law changed if you need to. Hayden did not. There is absolutely no need to balance security mission of content. As you know, this debate about electronic surveillance involves two All right, could we have the metadata slide,
Mr.
please?
Wiebe, can I briefly interrupt? I think
yes, you yes.
To read from the screen, but I'm just telling my colleagues here, it's in your files.
For your committee. Content would be the content of a Microsoft Word document, for example, or the body of an email, or the content of a telephone call. Those are examples of content. Whereas metadata are descriptors of content. For example, when you make a phone call, you use a telephone number. The telephone number that you are calling from and the recipient's phone number are examples of metadata. We call this kind of data addressing. Just like you have an email address. You probably have an identified content within the email are metadata. All names of people's places and things are metadata. Account numbers, license plate numbers are metadata. information describing photographs, the title of the photograph, how big the photograph is in pixels, be tracking Bob. Do we have the one that says, yeah, you had it, that's it. I want to give you examples of the threat. In this country, the United States, content may not be revealed without a court order. However, metadata is open to inspection by anyone according to U.S. law. The threat is that with metadata, every time a human being touches an electronic information system, they leave a marker. They leave an imprint. And those imprints are records that can be collected by those who wish to do electronic surveillance. And they can be aligned in time so that as you interface with information systems, the record can be placed against a calendar and a clock to see what you were doing when you interfaced with each of those electronic systems. Tracking Bob begins around 6 in the morning and ends at about 10:37 at night, and you can see the examples of the kinds of electronic transaction that he participates in and the records that it leaves. We can move to the slide of illegal use of private information. It's entitled U.S. Drug Enforcement Agency Special Ops Division. This item is very new. You may have not seen it. The slides I have show two depictions of rules being followed by this organization. And what it essentially shows is that NSA information is being used by other U.S. government agencies to pursue their responsibilities. In this case, obviously, U.S. drug enforcement is interested in criminal activity involving the use or transmittal or selling of drugs and the like. The bothersome part of this, if you'll go to the second slide, illegal use of private information, the Special Operations Division is masking, covering up, if you will, the source of the information. Now, what this does for someone who has been indicted or prosecuted by the U.S. legal system is to remove any hope of facing one's accusers in a court of law, because the person will never find out that the information came from NSA. So this special division of DEA is told to cover up the source to make it look like the data came out of a typical investigation by law enforcement, perhaps the FBI or someone else. The authority for the mass collection of telephone metadata in the United States comes from a Supreme Court case, Smith versus Maryland from 1979. I raise this case because it is upon this ruling that the entire U.S. surveillance structure is resting its case, demanding that it have free access to metadata of every sort. In this particular case, it involved a thief and his victim. The thief called his victim to harass her. The police installed a recording device that recorded the fact that he had made this phone call and used that evidence in court to prove that he was the committer of the crime and the person doing the harassment via electronic means. The government says the single use of metadata then allows the government to collect metadata en masse. This is a leap of logic that I frankly, that our whole world, our daily lives would be permeated with the use of electronic devices, electronic transactions, toll road transponders, bank account transactions, credit card usage, and the like. The Fourth Amendment to the United States Constitution, and I read to be secure in their persons, houses, papers, and effects against but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. This is the standard, and I do not know European law, but I would assume that many of your own privacy laws read very much the same. It requires factual information that defines a suspect in a criminal investigation, not just a guess or some non-scientific research. The final graph that I want to show you is entitled Focus of Analysis, 1 degree and 2 degrees of separation. Electronic transactions and computer systems are the threat to privacy, but I would argue the same tools are useful to guarantee privacy. Analysis can be conducted without ever breaking the rules governing the privacy of the individual. In the example on this particular slide, I have one person named John Doe, resides in Chula Vista, California. He is a known bad person. He's a criminal or a terrorist or something of that nature. He has contacts with another entity that is colored in yellow. Yellow dots in this graph are suspects. They have not been proven to be guilty of anything. Now, this technique allows them to be represented in this visual depiction. They're in a relation to provide a unique identity without disclosing the private information of the actual persons. This is eminently doable in software. There is no need to expose intelligence analysts to the identification of innocent people. In this example, the intelligence analysts would continue to watch activity, indicating the guilt or the probable guilt of the yellow dot with whom he is communicating, then that information would be submitted to not necessarily veiling an identity, could be defined in software, in a computer system. We call it commonly a business rule or a set of business rules, such that the court process defined by the court, the criteria defined by the court, could then be played against the data that a surveillance agency authorized to do this kind of work, and the decision could be made automatically, virtually in microseconds, certainly not longer than seconds, if this kind of technique were used. So this type of encrypted protect innocent people protects the innocent. And that is my content.
Interrupting you. Can you hear me? But we have to come to a conclusion.
Yes.
Because people also want to ask
And
questions.
I am finished.
I have the ungrateful task of keeping an eye on the clock. So if you could please... very much. Okay, I feel embarrassed now. Okay, we're video link. Okay with everybody? Mr. Moraes? No questions? Okay, then we come to Mr. Vos from the EPP group. I believe the questions will come to you in English. If there is a...
Ich habe eine Frage. Sie haben hinsichtlich...
I've got a question. You were talking the evaluation of the data was just to do with risks, or was it a general...
Yes. In the United States, the NSA Charter permits it to investigate intelligence questions of virtually any kind as long as the focus is against foreign targets, foreign to the United States. It's a matter of separate agreements with member nations around the globe. And some of those relations are tempered by partnerships with surveillance organizations among residents in terms of broad sharing or narrow sharing, depends on those agreements.
Okay, thank you very much. The next question by Mr. Albrecht from the Greens.
Thank you very much. I would like to know to what extent did you envisage abroad?
Is not so much the issue, because as long as it's gateways and perhaps encryption. This is why I would say to protect data, wherever it is, it should be highly encrypted. And the key to decrypt the data should not be in the hands of the intelligence surveillance organizations. It should be in the hands of a court of justice or some neutral body that ensures that the decrypt algorithms are not available to anyone for use as they see or so desire. So is it preferable that so encryption is really the barrier that must be used to do this? In the technique that I have shown you in this last view graph with the connect the dots, does not need retention of data that is not associated with criminal activity or terrorist activity. This could be okayed through a court, and then the data could be retrieved on a case-by-case basis. So that's the kind of operating schema that we would envision for this.
Thank you. There is nobody here on behalf of the ECR group, then the GUE.
So you are specifically about that and what the effects of that high
and methods. Those are the two things that must be protected. Traditional barrier between intelligence and law enforcement, and that barrier was there on purpose so that we didn't state, and a growing use of secret information across government agencies. So we now have an example gathered by Reuters, and that's there are two slides in your package that talk about the Special Operations Division of the Drug Enforcement Agency that depict just the circumstance you're talking about. How that affects was not truly authorized by your own government to be used for that purpose. In other words, threatening activity that will undermine or can undermine many of our civil liberties in this area.
Okay, thank you. I'll allow one question from a non-shadow rapporteur, Mrs. Morvai, if you can be really, really brief. We're running out of time.
Thanks very much, Mr. Wiebe, as an ex-NSA senior analyst, what would be you want to fight terrorists with this data collection? And question number two, to your knowledge, where was the base? I mean, it's obvious that it was not used for anti-terrorist purposes. Who used all the data that was ordered from the NSA, and what was the purpose? Thank you very much.
Sure. An organization doing electronic surveillance for valid reasons does not need, but again, it's based on probable cause, so the process is intended to crawl into the world of data, and I mean metadata and content. The focus should always be on those entities closest to criminal activity. Where you don't know of a criminal and you're just simply looking for evidence of criminal activity, things like jihadi websites, people involved in Islamic radicalization, people discussing or talking about the sale of narcotics and things of that nature on the web, data that can be searched readily and is open to the public. That's where you find starting points. But if you have a known starting point, as in my example shown earlier, you don't need all the data in the world to go after those few relationships that person has with the other entities in the world, and that should be the focus of your intelligence analysis. So I say you don't need all the data first to succeed. You simply need the relevant data to 1 or 2 degrees of separation from the beginning point, in this case, John Doe. That is the data that we need, nothing beyond. Now, you asked, where is the data for Bob? It could be resident with internet service providers, telephone companies. It could be out there in the world of commerce. Think of the data that goes down the internet pipe, if you will. Wherever that data is, it could be obtained through a court order, duly ruled upon by a legal authority such as a judge, or through a set of software defined by a judge or a court of law. So again, you don't need to grab it all, put it in a huge database, and hope someday that you'll need it. Not necessary.
Sorry, Mrs. Morvai. I have one final. We're running out of time. We're running late, and I'd really like to put in a question myself on behalf of the Liberals, and then we'll get to the next round. Two questions. You mentioned ethos at the NSA. Mr. Drake mentioned the Constitution. I wouldn't be surprised if we hear something similar from Mrs. Machon afterwards. I mean, you started working at the NSA assuming that you have that you were working in a specific constitutional context. What is the atmosphere like? Are other people having doubts? Do other people feel that we're in the hands of courts? But surely you do not mean the FISA court, which obviously doesn't work.
I became a whistleblower for 2 reasons. I witnessed corruption and mismanagement within the NSA on major intelligence production programs, one of which was in the news and was called Trailblazer. It occurred during Michael Hayden's directorship at NSA. And we knew, a few of us in the building at the time, that it was going to fail because the premise that it was built upon was poorly thought through. So this often happens in large organizations where good ideas get trampled by popular ideas or ideas that are driven by other agendas, such as perhaps granting large contracts to major commercial interests. And that is aided and abetted by those in Congress who have connections to those business interests. So many of these corruption problems are caused by our own governments. And the other reason I criticized was because Mr. Binney, my colleague, received information that the NSA was illegally collecting and looking at data that it was not authorized to look at, namely data associated with U.S. citizens. Now, what was your second question again?
Well, I asked if other people feel free and safe to come out and criticize or blow the whistle.
Yes.
My second question was about the FISA court.
No, people do not feel safe. I have to believe there are others that would love the chance to come forward, but because they have jobs and depend on the government for their incomes and their welfare, they are afraid to do so. So it's a terrible kind of suppression of free information. But I'm certain there are others that would like to come out.
Okay, thank you very much, and thank you very much for joining us. Those were our questions.
My pleasure.
And all the best. Then we'll continue. We're a little bit behind schedule now. Our last speaker in this session is Mrs. Machon. I hope I got it right now, from former MI5
Okay.
official.
Thank you very much for inviting me to make a statement to this committee. I'm going to be talking a bit about the UK setup, the intelligence world, and the legal regulations and restrictions, and also around what happens to whistleblowers coming out of UK intelligence. I then have a few recommendations which I would respectfully like to put in front of the committee, which I would hope would generate a little more discussion later on this afternoon. For those of you who are unfamiliar with the UK intelligence setup, our agencies have been around much longer than the US. They're just over 100 years old now, and for the first 80 years of their existence, they didn't officially exist. Our members of parliament were not allowed to ask questions to find out what they were doing. And a law was put in place soon after their inception in 1911, the very first Official Secrets Act, which was there to try and prevent the leaking and betrayal of national security secrets to our enemy powers. If you were found guilty under this law, you were a traitor and you received 14 years in prison, and this law is still in place. However, after their 80 years of, as the 80s spycatcher novelist, writer Peter Wright once said, bugging and burgling their way around London with impunity, in the 1980s, there were a series of whistleblowing scandals, and as a result of this, some more laws were put in place, which were key to the later development of what I want to talk about today. First of all, the Official Secrets Act was updated. Because of the whistleblowing scandals in the 1980s, they stripped out what had existed before, which was if someone blew the whistle, they could exercise a public interest defence. This was removed from the '89 Act, and what was put in place is what the lawyers call a clear, bright line against disclosure, which means that if you are a former or serving intelligence officer, you automatically break the law if you talk about your work to anyone outside the agency for which you work. However, at the same time, in 1989, they set up the Security Service Act to regulate the work of MI5 to a more democratic degree. And then in 1994, MI6, the International Intelligence Gathering Agency, and our listening post at GCHQ were also put on a legal footing with the 1994 Intelligence Services Act. And this act was key as well because for the very first time, it set in place a committee in Parliament which was supposedly to have some sort of notional oversight of the work of the intelligence agencies. However, until this year, that committee, the Intelligence and Security Committee, has been toothless because it was only able to investigate policy, finance and administration. And as other scandals have unfolded in the last 20 years, they were unable to call for witnesses from the intelligence agencies, subpoena them, demand access to documents, or to investigate allegations of crime. So that's the current framework in the UK. And it's ironic, I find it somewhat ironic to be discussing the UK now, as of course they are very much the partners in crime, apparently, looking at the current NSA revelations from Edward Snowden. So I worked for MI5 in the 1990s, and this is why it was crucial to have all these new laws put in place when I joined, because it was probably the most ethical era of MI5's 100-year existence. Suddenly they're on a legal footing for the first time, and this is before the tragic events of 9/11, when the intelligence gloves came off. And yet, despite that, I and my former partner, a man called David Shaler, saw so many things going wrong in the 6 years we worked for MI5 that we felt compelled to resign and compelled to blow the whistle. We had raised our concerns on the inside, as had many of our peer group who were all resigning in record numbers around the same time. And yet we were told to shut up, not rock the boat, and just follow orders. There was no effective avenue for ventilation outside the intelligence agencies. So David Shaler and I helped him, decided to blow the whistle on a whole series of crimes that we saw being committed. And these sort of escalated over our years in MI5, starting with files on our government ministers. The very people who are supposed to hold the spies to account had secret information held on them by the spies. There were illegal phone taps of left-wing journalists, innocent people put in prison when MI5 had information that indicated they could be innocent, but they withheld it from the trial. IRA bombs that could and should have been prevented going off on UK streets, and then MI5 lying to government to cover up its mistakes. And most crucially for us, this was the case that made us quit, was MI6's involvement in funding a terrorist operation in Libya to try and assassinate Colonel Gaddafi in 1996. This went wrong. It was illegal under UK law, and innocent people were killed. We could not think of a more heinous act to have witnessed, and this is why we decided to resign and blow the whistle. And we knew we faced prosecution under the 1989 Official Secrets Act by going public. So we went literally on the run, a bit like Edward Snowden. And we had to live in hiding in France for a year, and then live in exile in France for another 2 years, because MI5 was trying to prosecute us. David, in fact, was prosecuted. He went to prison not once but twice. First of all, when the UK failed to extradite him from France to stand trial under the Official Secrets Act in 1988. And then, secondly, after he had returned to the UK voluntarily to stand trial for a breach of the Official Secrets Act, and he was found guilty in 2002. So it was a very frightening experience to go through, and of course we had to give up our jobs, our career prospects, our very way of life, and of course risk prison. And it wasn't just us who did that. David, as I said, went to prison. I was arrested, but his brother was arrested. His two best friends were arrested. Journalists were arrested and threatened with prosecution around this case for daring to expose the crimes of the spies. It was also a salutary lesson to us as well for what it's like to live under a state of constant possible surveillance, where you can't feel that you can have a private telephone conversation or send private emails, where you can't feel that you can have a private conversation in the privacy of your own home, even your bedroom, and also potentially where your friends may be pressured to report on you. And that's what it would be like to live under a Stasi-type state, and that's how we felt we had to live for a number of years. What was also interesting around the case was looking at how the media, who notionally should be able to hold the spies to account, could also be legally controlled. There is a raft of legislation in the UK that can be used to threaten the media, and is indeed being used at the moment to stifle media debate about the Edward Snowden case. These include injunctions, super injunctions where you can't even discuss there is an injunction. There are public interest immunity certificates that the government can use, which are like injunctions. They use the Terrorism Act to threaten journalists. They also have a voluntary system called the D-Notice Committee, and a D-Notice has been issued to stifle legitimate debate within our mainstream media about Edward Snowden. Finally, of course, it's not just the whistleblower in UK law who faces prosecution. Also, our journalists can be prosecuted under Section 5 of the 1989 Whistleblowers Act if they cause damage to national security by reporting the stories given to them by the whistleblowers. This is more draconian even than in Russia today. So it's a bit of a mess in the UK. There is notional oversight provision. For example, we do have the ISC, Intelligence and Security Committee, which I mentioned, but they have been largely toothless. And also many stories have emerged over the last decade to show that senior spies have admitted to getting away with lying to that committee, because they can, because the committee has no way of forcing the issue. The idea there is some notional democratic oversight. For example, if MI5 wants to bug our communications, then theoretically they have to get a Home Office warrant signed off by the minister who's their boss. Unfortunately, the politician only gets to see a summary of a summary of a summary of a summary of the intelligence case, and it's very easy for the spies to big up that intelligence case and ensure that they get the permission required. They can also go for what are called omnibus warrants, and that is what I think we're seeing, for example, with the GCHQ use of the tempora surveillance technique, which William Hague, our current Foreign Secretary, said of course was legal. Of course there was oversight under the ISA. But in fact, this seems to be in nebulous legal ground, because if this is an omnibus warrant covering millions or billions of communications, then one warrant being signed off every 6 months automatically is not efficient oversight. So, why is whistleblowing important in the UK? We don't have a written constitution. This is one of the issues that came up before. We don't have a written constitution, and we have effectively the least accountable and most legally protected of all intelligence communities in the Western world. And because of this incredibly closed mindset, we get a sort of groupthink building up on the inside. If you're told not to rock the boat, told not to question ethical decisions, then those who do have ethical qualms often resign, and those who don't stay and get promoted. And I think this is what we've seen, for example, with the allegations of MI5 and MI6 being involved in torture cases over the last decade, since 9/11. In the 1990s, the spies did not use torture. It was unethical and it was ineffectual and it created blowback. And they'd learnt this lesson the hard way in Northern Ireland in the 1970s. However, suddenly after 9/11, they seem to have forgotten those lessons, and perhaps this sort of closed mindset, this groupthink, self-perpetuating oligarchy and lack of ventilation allow them to take that moral slide down towards involvement in torture again. So whistleblowers can add, or ventilation can add, a very powerful check to that sort of dangerous moral slide, in my opinion. There's also, of course, a war on whistleblowers going on, particularly in the US, where I think Obama has used the Espionage Act more times to try and persecute whistleblowers in his brief presidency than all other presidents since 1917 combined. This is nothing if not a war on whistleblowers, and yet it contrasts, in my mind, very starkly with the treatment meted out to real spies. You'll probably remember the Russian spy ring, the illegals who were caught in America in 2010. And yet a deal was done and they were handed over to Russia with no prosecution under this Espionage Act, which is wheeled out time and again to persecute whistleblowers, legitimate whistleblowers in the US. And I think this hypocrisy is breathtaking. And I think we need whistleblowers now. With this encroaching surveillance state, with this global surveillance dystopia that is gradually emerging from the Snowden revelations, and also, of course, with the spread of other questionable activities around the world, things like CIA kill lists, the assassination of terrorist suspects without due process by the use of drones, the invasion of sovereign countries on dubious intelligence, which in the past, for example, with the invasion of Iraq, has been proven to have been based on lies. All these things cry out for the need for greater accountability and greater transparency. And it's only by having those two key aspects can we hope for greater justice. So what would be some recommendations I would like to throw into the process, to throw into the debate, because we're looking at the legal protection of whistleblowers. And one thing, particularly in the UK, I would suggest, is that we need meaningful parliamentary oversight, real parliamentary oversight. We need a parliamentary committee which is elected by Parliament, not appointed by the Prime Minister, which has full, wide-ranging legal powers to take the evidence of whistleblowers, to allow them a legal channel to go to, so they don't have to turn their lives inside out by exposing crimes of the spies. We also need the fact that this committee in Parliament would be trusted by the whistleblowers to carry out a real and effective investigation into any allegations of malfeasance by the spies. And this would include a full inquiry conducted, evidence gathered and taken from all sides, reforms applied, and indeed crimes, if they are found to have been committed, to be punished. At this stage, it's very easy for the spies and the spy masters to cover up and lie when they're caught out doing something wrong. I would also suggest that certainly in the UK, we need a legal definition of what constitutes national security, because we don't currently have that under the law. And much is made of, we need to protect national security, and often the spies will conflate that with the national interest, which is not a reason to shut up whistleblowers and impede their freedom of expression under Article 10.2 of the European Convention of Human Rights. So we need a proper legal definition and an understanding as well that to protect national security means that you have to protect the integrity and the future existence of your nation state. So the odd bomb going off on the streets is traumatizing and terrible, but it does not threaten the national integrity of the state. Some other quick suggestions. One would be, of course, there was some very good evidence put in by Duncan Campbell about the Echelon report from 10 years ago. That needs, in my view, to be revisited. It was a perfect opportunity for Europe to build its own key communications infrastructure, to break away from the American hegemony, and also to provide protection for its citizens, and also to try and ensure that the US complies with the European Convention on Human Rights and our standards within our communities and countries. Finally, and just quickly to conclude, we need technology policies that allow us to protect ourselves if our states won't do that for us. So, for example, if we are unable to protect ourselves on the communications network, what we can do is take steps as individual citizens to protect ourselves, take our own steps, move away from the US proprietary closed corporate software systems and develop our own, because it would be good for our EU economy too. And finally, why do we all do this as whistleblowers? Just to finish, we need free media, we need a free internet, because if we don't have that, if we can't read and write and listen and discuss ideas freely and in privacy, we are indeed living in an Orwellian dystopia, and we're all potentially at risk. The central societal function of privacy in our communications is not just so that we can chat away to each other with nobody eavesdropping, although it's very corrosive to feel that you are being surveyed and listened to all the time, as I've experienced personally myself. But privacy, private communications, is the bedrock and defence against encroaching surveillance states and potentially encroaching extremist states. And as we've seen, for example, the rise of Golden Dawn in Greece, who can say where our political systems will take us in future? And this is why we need to protect and ensure our privacy now. So just as a final comment, I would suggest that there is no balance between privacy and security, is the argument that the spies and the intelligence agencies always bring out. They trot it out, that we have to get this balance between privacy and security. I would suggest this is a false dichotomy. We need that privacy in order to have that security, that we will not be predated on by potentially hostile powers. Thank you very much.
Thank you very much. Now I'm going to open the question and answer session to Mr. Drake and Ms. Marchon. We do the usual routine. Though, just to be practical, we are seriously behind schedule now, so I'm already going to, first of all, inform the rapporteur here that we will probably reduce your 10 minutes of drawing conclusions to 1.
I don't want
okay, we've just gained 10 minutes.
Right, yeah.
And I'm also already going to mentally prepare the speakers at the next session that I'm going to ask them to be even more brief than you were already prepared to do, because we're really behind time, and we have to finish at 6:30 because of the interpretation. Mr. Moraes, the rapporteur.
Yeah, I'll spare you from my conclusions. You were all here, but anyway, my question may seem mundane given the intensity of all of these contributions, but one of the big things we have to do in our report finally is to understand what the space is philosophically and practically for whistleblowers, where you sit and where you actually say what you have to say. Now, in the US experience, you have this Presidential Policy Directive 19, which President Obama talked about. Now, I know what you're going to say about this, that it doesn't really provide whistleblowers with anything to say. I know you're going to say that. But you need to explain to us on the record what it means. That gives whistleblowers the internal possibility of saying something according to the US authorities. But if it doesn't, then tell us where a whistleblower in the United States from the NSA who genuinely sees something happening can say it in any sort of safety. If they can't, then what does that say for any whistleblower? Does it mean there is no scope? Is there any legislative scope at all? And then what, in your opinion, does it say for us here in the European Union or in any of the member states? And for the United Kingdom example, I mean, I'm very familiar with the UK, and I would just say that it isn't really much to do with the unwritten constitution, because we have many examples in other member states with written constitutions where we have the same problems of lack of national intelligence scrutiny. But again, for whistleblowers in individual member states, we don't have parliamentary scrutiny in most member states. We've already learned that. So again, for individual EU member states, there is insufficient protection. So in some more detail, what would you see are the protections we should recommend here in the European Parliament, finally in the report?
Okay, thank you. I'm going to ask all the speakers to really stick to 2 minutes max. You can even be shorter if you want. Mr. Vos for the EPP.
Ich würde gerne wieder auf Deutsch sprechen.
I'd like to speak German again. Of course, we're all trying to strike the necessary balance between the security we need and the necessary privacy. As far as I understand it, we're also trying to establish to what extent at all, with all this data surveillance, we can still maintain the rule of law. And so I'd like to ask you both whether the data which are collected predominantly or at all are used without the necessary entitlements. Are they used and evaluated without those powers? And are the data being used for industrial espionage or for political espionage? Or are they actually being used to fend off potential dangers? So I'd like to hear what you know about that.
Mr. Albrecht.
Thank you, first of all, for being here, for bringing us your views. It's very important for us, and I think one thing is very important, and that's the first part of my question. Which is the actual scale which you have seen of blanket retention by these intelligence services? I mean, you have been, Mr. Drake, with the NSA until 2006. You know what happened until then, and it would be very important for us to know to which extent that happened at that time, and also in the MI5. I think that would be helpful to get an insight of what is actually happening and possible. And the second part of my question would be, you talked about oversight so parliamentary oversight. How do you see that this could be done effectively? That is the big question. We need to answer it, and that's what we want to do here in the European Parliament. So if you have recommendations to that, I would be very happy. And of course on whistleblower protection, but you already said quite a lot. But if you could concretely say something on data protection rules, that would be helpful. Thank you.
Thank you. Nobody on behalf of the ECR. So then we go to GUE. Mrs. Ernst.
Ja, vielen Dank.
Thank you very much. Well, firstly, I'm very pleased. I'd like to express my respect for the fact that you're here. It's really a very good day for us, I think. And so 2 questions to you, please. Firstly, parliamentary scrutiny. How is it possible? You said, Mrs. Mahon, that we ought to have an independent parliamentary scrutiny committee, and how could that actually be done at European and national level in tangible terms? And my second point, which is very dear to my heart, what kind of legislation could we have in place to protect whistleblowers? Something needs to be done. On what level should it be? What should we be doing? I've read something from you in the form of some regulations, and I thought that was very good. But when it comes to protecting whistleblowers, that's really a red line as far as we're concerned in our discussions on data protection. I really think that something needs to be done in the strongest possible terms, and I would just like you to give us some pointers on that.
Thank you, Mrs. Ernst. Then I will ask the last question in this round on behalf of ALDE, a shadow of ALDE. I was rather struck by the expression you used, the war on whistleblowers, which is really, if you listen carefully, the war on democracy. Because if all the oversight mechanisms don't work, if the transparency mechanisms don't work, then basically whistleblowers are the only instrument we have left, if you'll excuse me for using the word instrument to indicate you, to know what's going on. Because, I mean, as unbelievable as it may sound, this all gives the impression of completely runaway secret services, behaving like Dirty Harry and cowboys. The word ethos somehow, sits. And I have two questions. There's still people there are actually people, members of this House, who have called whistleblowers criminals who should be convicted. Unfortunately, the people who said that aren't present here today. They didn't feel the need to come. But what would you say to those people who say whistleblowers are criminals and these programs are necessary to keep us safe? Are we naive or are they just seriously misguided? My second question is, why do bodies like Congress or indeed the British Parliament or any other national parliament, why do they accept to be led by the nose? Why do they accept that? Why do they accept, I mean, you know, there seems to be a state in the state, but if we pretend that we are a democracy, if we believe that we have the moral authority to lecture the rest of the world, then why is it that parliaments don't function? Why don't they exercise their rights of scrutiny? Why don't they do their duties? That is what I cannot understand. I hope you can answer. Shall I start with Mr. Drake for answering the questions?
In terms of whistleblower protection, I'll defer to the statement and testimony of Jesselyn Radack that's coming up. I believe she can provide you insight in that regard. The fact remains, in my case, I was completely exposed. Any existing law that existed was a paper tiger, and I had no cause of action or recourse in the court system. And there's a lot more to say on that, but I'll defer to Ms. Radack. The data retention question, rule of law, the issue is actually under U.S. law, going back to the normative understandings foundation of the Fourth Amendment. You must have a probable cause supported by an affidavit, and it doesn't matter what's happened here. Is it in the greatest of secrecy, and now we're starting to see even more of the disclosures of how far that actually went. You can't, basically the government has decided to simply seize and then search later. The threshold is actually at the search point, the particularized search, the particularized place, location, and what are those items you wish to seize. The question about industrial, financial, or other forms of espionage, I believe the disclosures that you are seeing in the press are significant evidence pointing to the use of intelligence or repurposing intelligence based on secret accesses for other reasons. This has been one of the great elephants in the room, is beyond just the claim of having intelligence to quote-unquote defeat or protect or to blunt terrorism and other related activities. When you have that kind of information, what else could it be used for? It could also be used, I would add, for political purposes. In terms of the scale, I actually was at NSA until 2008. I was aware of the beginning foundations of the PRISM program. That was basically the attempt by the U.S. government to put what had been disclosed in the previous 2 years back into a much larger Foreign Intelligence Surveillance Act box, and then secretly interpret it to continue to have access, unfettered access, to what they have been doing for the previous 4 or 5 years. NSA, frankly, had unfettered access without any of the intervening Enabling Act legislation, and then secretly reinterpreted Section 215 of the Patriot Act in 2006 under a relevancy clause to gain access to staggering amounts of data, including all phone records from the major telcos. So for me, it's sort of an echo chamber effect. The Snowden disclosures, in fact, are simply evidence of the industrial scale and nature that's become very much normalized, institutionalized. In terms of oversight, I say this somewhat tongue-in-cheek, but quite serious. What we have are undersight committees in the U.S. legislature. They're completely compromised. There's only a few senators and representatives who are willing to stand up. Part of it is another elephant in the room, is there's tremendous amounts of money, part of what I blew the whistle on, staggering amounts of money being made by private corporations in league with the government for surveillance. Surveillance, frankly, is a huge growth industry. And you have not just corporations selling data, monetizing data for a profit. They get to do the same thing by selling the subscriber information to the government, and they're not doing so gratis, believe me. War on democracy is extraordinarily critical and insightful way of saying it. That's ultimately what's at stake here, are the very foundations of democracy. Something has to give. And when you have secret laws and secret evidence and secret courts and secret opinions, then democracy itself is imperiled. And history is not kind. The problem is we have extraordinary technology, and I would certainly urge, in the strongest possible language, that this body seriously consider what is absolutely necessary to protect the sovereignty and integrity of your member nations, but most importantly, the sovereignty of your individual citizens. What you're seeing is the replacement of the rule of law. That is the great equalizer by a pernicious form of authoritarianism. And there is history in this continent alone, having lived here myself for over 6 years, there is history that I think should speak extraordinarily powerfully in terms of what happens when you live inside authoritarian and even fascist states.
Thank you. Ms. Machon.
I shall try and keep these as brief as possible, and perhaps there seem to be a number of similar themes coming out from the questions, so if I can conflate them. First of all, how can we protect whistleblowers or beef up the oversight or draw up laws? What's necessary to protect future whistleblowers, if possible, within the EU? I think certainly the setting up of parliamentary committees, meaningful parliamentary committees with proper legal powers to investigate allegations of crime coming from within the intelligence agencies in all our countries would be a good first step, and they would have to prove themselves and be seen to properly investigate these operations. That would be a good first step. Then we could also try and institute some greater protections for the individual whistleblowers. So, for example, in the UK, there is a law in place called the Public Interest Disclosure Act 1998, which is there to protect whistleblowers. So they can't be victimised, they cannot be sacked, etc. Of course, the intelligence agencies are specifically excluded from that, as they are specifically excluded from the Freedom of Information Act we have. Perhaps we should think about including them under some of these sort of legislations. The other thing to bear in mind is that even within the spy agencies themselves, they only reckon that there are 3 types of secrets that really need to be kept secret, and they're logical. Ongoing operations, which, if they're exposed, would blow the operation. Sensitive operational techniques. Well, I mean, that's blown wide open now with the NSA scandal. But in the UK, for example, we still can't use telephone intercept in legal cases because it's supposed to be secret. So that's how ridiculous the law can be. And the third point which needs to be kept secret is agent names, those who are infiltrating groups on our behalf and risking their lives, of course. But even within the spy agencies, that is what they acknowledge needs to be kept secret. Yeah, if there's an operation 5 years ago and that comes out, so what? But we still, as citizens, need to know fairly relative intelligence operations in order to have an informed perspective when we then go to vote for what sort of parliamentary people we want in there who will control the intelligence agencies. So, in terms of real secrets, perhaps a reform of, in the UK, the Official Secrets Act 1989. Let's put back the public interest defence that was taken out specifically to get whistleblowers. And in fact, most of the people who then went on to become the Labour government voted against the removal of this public interest defence. So I think that also needs to go back in. So that's all at a national level. Just one point on the European parliamentary level. Perhaps if those national oversight bodies fail, there could be a sort of an appeal route or something that European citizens from any country, intelligence whistleblowers from any country, could then appeal to this body for help in not having to go to prison, in getting investigations into spy crimes investigated. Picking up on the war on democracy as well, I think you are absolutely right. And I think the tensions have been, the intelligence agencies have been well aware of the tensions building between the digital natives, the spread of the internet, and the spread of free speech and ideas and knowledge, and their power to control us. So I would call it almost like an arms race, what has been going on with the NSA, certainly, and GCHQ, certainly, over the last 10, 15 years, where they are trying to get more and vaster ways of taking away our privacy, working out what we're thinking and reading and who we're meeting and what our strategies are. So it's an arms race between us. And I think this is a last chance for the European community to make a stand and say, let's not go down this path. Let's not be taken over by these sort of technologies. And we can do that. I know you've heard evidence from other more technologically expert people than I, but we can do this by weaning ourselves off our US internet dependencies, creating the jobs, creating our own infrastructure, creating the educational values that will protect us as citizens within the EU, because as the European Parliament, your first duty is to protect the EU citizens. Just one final thing, picking up on the point about, are we traitors? Well, of course, some people say that. I wish those people had been here today, because I would love them to hear this answer. And it's something that's been thrown at me and many other whistleblowers time and again. I signed up, and I signed the Official Secrets Act. I signed up to make a difference. I was motivated to have a job that could potentially save lives, and that motivation is what carried me through into blowing the whistle to potentially save future lives from spy crimes. And I signed the Official Secrets Act to protect official secrets, which is what I have done and what I will continue to do for all the successful operations that I saw or was involved in. However, I did not sign up to protect unofficial secrets and spy crimes. And that's all I and David ever exposed in the public interest. And if we'd been prosecuted under the 1911 Official Secrets Act, we would have had that defence. He wouldn't have had to go to prison. So why on earth are the criminals within the intelligence agencies not the ones on trial? The people who were involved in MI6 funding Al-Qaeda associates in Libya in 1996 were never even questioned by the police. They were certainly not charged with conspiracy to murder.
I'll start with the last first. I took an oath to support and defend the Constitution. It was a grand experiment launched over 20 years ago, and it was an idea and how to best govern ourselves back across the Atlantic Ocean. An idea. And similar to Annie Michon, I didn't take an oath to secrecy. I didn't take an oath to illegalities. I didn't take an oath to violating the sovereignty of people. And so it's fundamental to why I stood up. I recognize, and as I've met other colleagues who've done similar crisis of conscience, that was what I chose to do for the future. It wasn't me, it was about others. I could not stand by and see this aversion of the very way of life that I had taken oath to support and defend 4 times in my government career. And I did so knowing that it was at great risk, particularly in the post-9/11 world. And I stayed as long as I could within the system until I could no longer remain. In terms of the Stasi, I'm really reflecting, you say dictatorship. Yeah, there's powerful interests, both political and corporate. I have referred to it as soft tyranny. The problem is with the kind of technology we have, it doesn't take much for the surveillance state, particularly if you've seen the recent revelations, to find out just about anything there is on just about anybody at any time. I'm going to the other question about NSA. NSA actually came to internet late, and the reason is they didn't think there was anything worth knowing on internet because it was open. The only things worth knowing were those things that were secret, ironically enough. That dramatically changed in the years preceding 9/11, and I'll just briefly say that during the presidential transition team under George Bush in the year 2000, the fall of 2000, NSA actually, and it's out there on the internet, put together a paper that would significantly erode the probable cause standard of the Fourth Amendment. They were already looking for ways, and when 9/11 occurred, it simply became the pretextual justification to expand the surveillance state in a quite significant manner. I think that answers most of the questions that I recall. Thank you, Chair.
Okay, thank you, Mrs. Machon.
Well, those are very interesting questions, thank you, and I could actually do a whole new talk on them, but I shall skip quickly through the key points. First of all, are politicians in the UK or media types compelled by the spies to do their bidding because of secret information held on them. They are never allowed to see what's held on them. Even if they are the Home Secretary in charge of MI5 or the Foreign Secretary in charge of MI6 and GCHQ, they are not, even at that time, allowed to see the files held on them. So, for example, Jack Straw, when he was Foreign Secretary or Home Secretary, was not allowed to. So they don't know what the spies know about them. But you can imagine with politicians, all, some of the little guilty secrets or that affair might come back or something like that. And with journalists, exactly the same thing. Because they don't know, that causes greater fear, potentially, in their minds. And that, I think, particularly is why the former Labour government was so keen to kowtow to the intelligence community and to shred and give them lots of more resources and powers in the noughties. Do they look at wider political causes? Yes, and they have done. And so do the undercover police officers, which sort of inherited this work, political work, from the spies in the 1990s. But I think what is more concerning is how the goalposts are moving within UK law, so that the undercover cops, the police officers, were investigating domestic extremists, even though that is not a category recognised under UK law. And groups which are pure activist groups, such as Occupy in the City of London, were deemed by the City of London police to be domestic extremist/terrorist group. And we all know how terrorists can be treated under the law these days. So the goalposts themselves can move. And if they change the definition of what your activist group is, you become a legitimate target. And that's a real danger in a democracy. Why do they keep holding on to power? It's jobs for the boys, essentially. So when the Cold War ended, what were we going to do? We had MI5 with all this free time on their hands. Let's give them IRA terrorism to work on. Oh, we have the peace process in Northern Ireland. Let's give them Al-Qaeda to work on. Rather than taking a step back and saying, what are the threats to our real national security, our national existential integrity, and how do we best protect ourselves from those threats? And that if MI5 is not up to the job, then get rid of it. Set up a counter-terrorism agency made of the best and the bright from the police and the spooks or whatever, and make sure they work under the conditions that the police have to work under, evidentially and with accountability and oversight. We have MI5 policing terrorist groups in secret with no accountability when they're supposed to be doing a police-type job. Finally, are we living under a dictatorship? I would go back to Mussolini's famous quote about what is fascism, what is the pure definition of fascism. And his view was the merger of the corporate and the state. Now, looking at these mega global corporations, looking at the lobby groups that can and have influenced certain key legislation, even in this august institution, like the ACTA, the Anti-Copyright Trade Agreement last year, which activists heard, most MEPs were not even allowed to read, they were just expected to sign. That is corporations taking over the function of the state. And I think this is just one final comment. This takes us back as well to the valedictory warnings from history of the outgoing President Eisenhower in 1961 in the US, where he warned of the military-industrial complex. I think this has morphed hideously, Hydra-like, into the military security intelligence complex. And security particularly, and war on terror particularly, and intelligence and surveillance particularly, are very good for big business and mega corporations, as Thomas Drake mentioned earlier. Thank you very much for your time.
Thank you very much, and I apologize again for the confusion earlier on. That concludes this session. Then we are going to the last session. I'm going to invite the next speakers to join us on the podium. I apologize to you, because your speeches will be cut short a little bit. I'm going to ask you to each speak for a maximum of 10 minutes. Then we'll have 10 minutes left for a question and answer, so we'll have to be really quick. And if we need a few more minutes, I'm going to look very kindly at the interpreters and ask them if they could spare us a few more minutes and extend the meeting a little bit. As you're taking your seats, very welcome here. We have two speakers from NGOs active in the legal protection of whistleblowers. The first speaker to my right is Mrs. Jesselyn Radack. I hope I pronounced that correctly. National Security and Human Rights Director at the Government Accountability Project, representing 6 whistleblowers, including Mr. Drake and Mr. Wiebe. And after that, we'll hear Mr. John David. Is that correct? David, sorry. Chief Executive of Transparency International in Ireland. I'm first going to invite Mrs. Radack to take the floor for about 10 minutes.
Thank you. to the European Parliament for inviting me to contribute to this significant and historic series of hearings. I commend the LIBE Committee for their attention to the secret and illegal surveillance operations that National Security Agency whistleblower Edward Snowden brought to light. It is my hope that similar political bodies around the world will follow your example. Without courageous whistleblowers like Mr. Snowden, the world would not know the enormity of the NSA surveillance activities in my country or in member states. Instead, the public would rely on half-truths and outright lies from U.S. government officials. Mr. Snowden's disclosures have brought to the forefront a much-needed public debate about the U.S. government's exorbitant, expansive, and often ineffective surveillance apparatus. I head the National Security and Human Rights Program at the Government Accountability Project, the leading whistleblower protection organization in the United States. As a whistleblower attorney, I've seen the workplace retaliation that usually happens to whistleblowers time and again, the scathing performance reviews, demotions, and often termination when employees reveal gross fraud, waste, abuse, and illegality. It was in 2010, however, when I was first introduced to the draconian and clandestine world of the National Security Agency. That was a year I began representing Thomas Drake, from whom you just heard. I myself am a whistleblower. I blew the whistle on government misconduct in the United States' first high-profile terrorism prosecution after 9/11. I learned firsthand that the Bush administration was willing to escalate retaliation against whistleblowers, destroying not only their jobs, but their careers by going after their security clearances and their professional licenses and putting them on terrorist watch lists. But when President Obama's administration indicted Thomas Drake and did so under the Espionage Act, the most serious charge that can be leveled against an American, I knew the U.S. crossed the Rubicon by criminalizing the truth. Although the prosecution of Mr. Drake collapsed, the United States government continued to indict national security and intelligence community whistleblowers for espionage. Employees in these communities have no whistleblower protection and have been specifically excluded. The fact remains that in less than a year, President Obama indicted more people under the Espionage Act, most of whom are whistleblowers, than all previous presidents combined. The witch hunt intensified with the historic, earth-shattering revelations of WikiLeaks, a publishing organization committed to transparency, which published the largest trove of secret documents in the history of the world, those disclosed by Private Chelsea Manning. Under the extraordinary leadership of Julian Assange, himself under a sealed U.S. indictment and in his own virtual imprisonment in the Ecuadorian embassy in London, WikiLeaks has literally changed the face of journalism, been an unfailing supporter of all whistleblowers, and redefined transparency in the digital age. The U.S., however, has tried in myriad ways to criminalize whistleblowing and reporters associated with it in order to send a chilling message to anyone even thinking of speaking truth to power. What the U.S. government calls espionage, I call having moral courage to express and expose some of the most egregious, tightly held illegalities of the past decade, including torture, war crimes, and mass surveillance on an unprecedented scale. The brave souls who exposed these things are individuals earnestly committed not to a president or to an agency or to a boss, but to the interest of their country and humanity at large. Historically, such people were forced to choose between their conscience and their career. But now the stakes are much higher. They risk their freedom and their lives. We are in the throes of an asymmetrical war on whistleblowers in the United States, and yet the war on whistleblowers has metastasized into a war on journalists. The reporters who work to publicize whistleblower disclosures are not only the subject of surveillance themselves, but are also now the subject of criminal subpoenas, search warrants, and threats of prosecution for simply doing their jobs. What is emerging from the war on whistleblowers, journalists, hacktivists, and dissidents is a larger, more insidious war on information. Why? Because we live in an information age, and information is the currency of power. What we are witnessing is a global power grab on a scale the world has never seen. You heard earlier today facts we now know to be true because of Mr. Snowden's revelations, including NSA increasingly engaging in massive cyber operations to hack into foreign computer networks of both friend and foe to steal information, sabotage infrastructure, and spy on citizens. And two, the U.S. has spent more than $500 billion on intelligence since 9/11 and has now exceeded the equivalent Cold War spending levels. In a breathtaking act of civic courage, one man pried open the most powerful secret intelligence agency in the world to benefit the global populace. In a cascade of revelations started by Glenn Greenwald and Laura Poitras, each revelation more disturbing than the one before, journalists around the world have been publicizing the information Mr. Snowden risked his life to release. This honorable body recognizes the significance of these revelations and how important they are to an informed public. I respectfully request that the committee strengthen laws to protect whistleblowers, laws to protect privacy, and laws to protect the rights of publishers in the European Union to disseminate such revelations without fear of criminal penalty. I hope this investigation can be expanded even further as more revelations emerge. As U.S. President Lincoln said 150 years ago, quote, "Worse than traitors in arms are men who pretend loyalty to the flag, feast and fatten on the misfortunes of the nation, leaving their countrymen moldering in the dust." That is what the surveillance profiteers have done since 9/11. In an orgy of greed, they have created a surveillance state the former East Germany would have envied. I hope my words today can do a small part in calling it out and reining it in. Having to choose liberty versus security is a false choice. We could live and have them both before 9/11 if NSA had listened to whistleblowers like Tom Drake and Kirk Wiebe. They had the ideas and knew how to, and had in fact implemented their lawful, inexpensive, and privacy-protecting program. NSA may be willing to trade democracy for despotism and surrender freedom to fear. I am not. Mr. Snowden wishes he could attend these hearings, but for obvious and frankly deplorable reasons he cannot. Instead, I will be reading his words to you, which is only possible due to two of the unsung heroes in his harrowing saga. Julian Assange and WikiLeaks journalist Sarah Harrison, who literally rescued him from Hong Kong, orchestrated his safe passage to Russia, helped him obtain asylum, and who, in the case of Sarah Harrison, have literally been by his side every step of the way at great personal risk to herself. They have been not just stops on the 21st century version of the Underground Railroad, which liberates information from the shackles of security and transports it into the disinfecting sunlight of freedom. They have been the guardian shepherds who have kept him safe during this difficult journey. It's a tragic irony that in an effort to preserve your liberties and mine, they all have given up so many liberties of their own. The treatment of Julian, Sarah, and Ed, the example being made of them and all other whistleblowers, is the ultimate chilling effect on speech. Statement of Edward Snowden. I thank the European Parliament and the LIBE Committee for taking up the challenge of mass surveillance. The surveillance of whole populations rather than individuals threatens to be the greatest human rights challenge of our time. The success of economies in developed nations relies increasingly on their creative output. And if that success is to continue, we must remember that creativity is the product of curiosity, which in turn is the product of privacy. A culture of secrecy has denied our societies the opportunity to determine the appropriate balance between the human right of privacy and the governmental interest in investigation. These are not decisions that should be made for a people, but only by the people after full, informed, and fearless debate. Yet public debate is not possible without public knowledge. And in my country, the cost for one in my position of returning public knowledge to public hands has been persecution and exile. If we are to enjoy such debates in the future, we cannot rely upon individual sacrifice. We must create better channels for people of conscience to inform not only trusted agents of government, but independent representatives of the public outside of government. When I began my work, it was with the sole intention of making possible the debate we see occurring here in this body and in many other bodies around the world. Today we see legislative bodies forming new committees, calling for investigations and proposing new solutions for modern problems. We see emboldened courts that are no longer afraid to consider critical questions of national security. We see brave executives remembering that if a public is prevented from knowing how they are being governed, the necessary result is that they are no longer self-governing. And we see the public reclaiming an equal seat at the table of government. The work of a generation is beginning here with your hearings, and you have the full measure of my gratitude and support. Edward Snowden.
Okay, thank you very much also for passing on his statement. Then we'll quickly move to Mr. David of Transparency International. You have the floor.
Thank you, Madam Chair. Many thanks to the committee for their invitation. It is a privilege to be sharing a platform with Jess and many other people I admire greatly. As a former public servant myself, I count myself very lucky that I never had to have my conscience or moral courage tested in the way that Kirk, Tom, Annie and others have. In many ways, Whistleblowers are people of conscience who find themselves in the wrong place at the wrong time. My role as an advocate of transparency and accountability is to help create workplaces and legal frameworks that embrace rather than isolate those that find themselves confronted with the choice between remaining silent and serving themselves or speaking up and serving the public interest. Equally, my job is to help remove the burden on individuals to defend the public interest and place more responsibility on public institutions to protect fundamental rights and the common good. To that end, TI chapters have been campaigning for institutional reform and legal protection for whistleblowers for the best part of 20 years. More recently, we published principles for whistleblower legislation for parliamentarians. We're due to soon publish a report on legal safeguards for whistleblowers in the European Union. We're also operating helplines in about 50 countries, and so far we've assisted some 140,000 clients around the world. TI Ireland launched the first helpline for victims of corruption and whistleblowers in Western Europe, or the first TI helpline in Western Europe 2 years ago. And we have helplines in the Czech Republic, Romania, Hungary and Luxembourg. Should also note the great work that Public Concern at Work are doing in the United Kingdom. They've led the agenda on whistleblower legislation, not just in the UK, but around the world too. We assume rightly that intelligence agencies are responsible for protecting us from attack and upholding democratic principles. But the anti-corruption community has, to a large degree, underestimated the potential for abuse by members of the intelligence and security services. We've seen comparatively few well-publicised cases involving whistleblowers from the intelligence community in the EU. You're no doubt familiar with the case of Frank Greville, who blew the whistle on Denmark's intelligence case for intervention or invasion, or the invasion of Iraq, as well as Annie and David Shaler's cases in the UK. In Ireland, we have not seen a public controversy surrounding intelligence services in around 40 years, not since allegations of support for the IRA by members of the Irish Military Intelligence Service surfaced in 1972. That said, we have seen patterns of behaviour elsewhere in the public service that might be familiar to intelligence community whistleblowers. In 2010, officials of the Department of Social Welfare in Ireland were found to be passing on personal data of Irish citizens to insurance companies and private investigators. Earlier this year, 2 police whistleblowers reported that Irish police were unlawfully manipulating and cancelling police traffic records for family members and other police officers. We have noted how the same police whistleblowers have fallen victim to reprisal by their colleagues and police management. We've also recently seen how a journalist, Gemma O'Doherty, was recently fired after she investigated reports that the Chief of Police had his traffic offences cancelled too. This message, or the message this sends to whistleblowers and journalists, is that reporting abuse is worse than the abuse itself. Information can be as valuable as any commodity or public asset. These cases demonstrate the risk of affording public servants undue discretion over the control of public or private property, including data. Without the systems to hold them to account. They also demonstrate the need to protect whistleblowers in the intelligence community who might expose similar abuses of personal data and citizen privacy. Intelligence whistleblowers are not afforded the legal right to blow the whistle on wrongdoing in intelligence agencies in most jurisdictions in the European Union. But intelligent whistleblowers are not alone. Most workers in all categories have few formal legal safeguards in the EU. This is in spite of the fact that, according to the Association for Certified Fraud Examiners, some 40% of fraud cases and corruption cases are exposed by whistleblowers. And while whistleblowers help detect wrongdoing, they also help prevent it happening in the first place. Workers who might be inclined to engage in wrongdoing may think twice if they know that their colleagues may report on that wrongdoing. Whistleblowers also help prevent many other forms of harm to the public interest. For example, the United Kingdom introduced whistleblower protection, the Public Interest Disclosure Act in 1998, after a series of disasters, including the capsizing of the Herald of Free Enterprise ferry in Zeebrugge with the loss of 193 lives, and the Clapham Rail Junction crash in 1988 with the loss of some 25 lives and 500 casualties. The UK government recognised that whistleblower protection and promotion could have helped in communicating the risk of dangerous practices that were not being addressed by employers. As it stands, the UK provides comprehensive, or is one of the few jurisdictions in the European Union that provides comprehensive and consistent measures aimed at protecting whistleblowers in both the public and private sectors. But as Annie mentioned, even the UK doesn't protect whistleblowers in the intelligence services. Most EU jurisdictions only allow whistleblowers from certain sectors, such as healthcare or childcare, to report concerns, or allow whistleblowers to report certain types of offences, such as fraud or child abuse. Legislation is also often written to define offences in restrictive ways. So while someone might be able to report corruption, for example, corruption may be strictly defined in law as the bribery of a public official. Whistleblowers might therefore not be protected if my computer's gone dead, sorry. Whistleblowers might therefore not be protected if they blow the whistle on the abuse of personal information or data, even where that abuse is for personal gain. This is particularly the case where that information is being abused by members of the security or intelligence services. Most EU jurisdictions also restrict the channels through which whistleblowers can report, and only allow whistleblowers to report to designated persons, such as their employers or through the police. A whistleblower might not be protected even if they accidentally report to the wrong person or public agency. These restrictions, I would suggest, are having a chilling effect on whistleblowers and whistleblowing, and the right of citizens to hold their public servants to account. TI, as well as the Council of Europe, have developed key principles for whistleblower legislation, which I mentioned earlier, and we would urge you to consider them in formulating any policy position or legislation on whistleblower protection in the European Union or its member states. I'll highlight three key principles which I think you should be cognizant of. Firstly, whistleblower law needs to provide protection for all workers, including those working in the defence and intelligence services, as well as contractors, trainees, as well as employees, and it should protect them against formal reprisals such as dismissal or demotion, as well as informal sanctions such as harassment or bullying. It should afford opportunity not just to expose corruption, it should afford the opportunity to whistleblowers not just to report corruption and fraud, but also waste, gross negligence and failure to perform legal duty, such as to protect the privacy or confidentiality of citizens' data. Finally, it should also provide safe but multiple channels through which whistleblowers can report their concerns, while encouraging whistleblowers to go internally where they need to be able to report, or while encouraging whistleblowers to report internally, they should also have the opportunity to report externally. It is now debating a comprehensive bill that draws from these principles and which are to a large degree premised on the experience of whistleblowers around the world. It will also allow intelligence officers an opportunity to report internally and to a government minister. However, I should note that legislation alone cannot fix what is essentially a failure of democratic institutions to uphold the values and principles upon which they were founded. National Integrity Systems research conducted by TI chapters shows the need for our public institutions to be routinely assessed and their commitment to the rule of law and transparency held up to public scrutiny. The public have a right to information and have a right to the information they need to hold governments to account, and our media needs to be afforded the freedom to bring that information to public attention. As the plight of whistleblowers and journalists in my own country and elsewhere in Europe show, there is much to be done to create environments in which people feel safe to speak truth to power. Thanks for your time.
Thank you very much. And again, I apologize to both of you for, being squeezed a little bit. Okay, I'm going to. Is there anybody other than the rapporteur and the shadows who, Mrs. Morvai? That's it, Mr. Brons, Mrs. Sippel. Okay, everybody gets 1 minute. We're going to have all questions, 1 minute strictly. So can you please watch the time, Mr. Rapporteur?
Thank you, particularly to Jesselyn Radack for that statement, and to John as well. You talked about these better channels for people of conscience to speak, and Thomas Drake mentioned that you would answer this question about how we are going to mention that in our report. But to avoid this situation where you have this Presidential Policy Directive 19, so where you have in the United States what you say is a channel for whistleblowers to talk about things internally. So my question is, did Edward Snowden do what he did? And I'm being devil's advocate here, because this internal structure for whistleblowing was completely inadequate. I'm sure you're going to say yes, but tell us about this. And is that why he had to say what he had to say in this dramatic and big way that he had to say it? And if we in the European Union have to avoid this, what do we recommend? You heard from Annie Machon that the Public Interest Disclosure Act, and it was mentioned by John Devitt, is inadequate. And if it's inadequate, what solutions have you thought about in the Government Accountability Project? 1 minute.
Okay, as a rapporteur, you got 9 seconds, but that doesn't apply to the others. This is a privilege. Mr. Vos, you have 60 seconds.
Auf Deutsch. So, vielen Dank für Ihre Berichte. Das war sehr interessant.
Thank you very much for your very interesting reports. My question is addressed in the same direction about these revelations or whistleblowing. Is the press the only way people can go, or are there internal or parliamentary opportunities for whistleblowing, or some independent body such as an ombudsman where this sort of information can be passed on without this exposing the person to danger? And I wonder if charges through a prosecution body might also be an appropriate and sensible way for a whistleblower to release information whilst guaranteeing their own personal security.
Recht is saving us 60 seconds by being absent, so is Mr. Kirkhope. That brings us to Mrs. Ernst.
Ja, das ging ja fix.
Well, that was quick. Well, I would like to also come back to the question of protection of whistleblowers. Now, on the question of the lack of protection, in fact, how should we think about whistleblowers? Should we see them, or are they seen as traitors, people who are outside the scope of the law? How are things currently being dealt with? And could you tell us quite clearly as to how you think whistleblowers should be protected? What rules should we see enforced to protect them?
Order, Mrs. Morvai, Mr. Brons, Mrs. Sippel, and I'll ask the last question myself. Mrs. Morvai.
Thank you so much. It is extremely moving to hear the personal message of Mr. Snowden to us. We also obviously wish him very well, and we are very grateful to him, at least I hope most of us. He said in his very first interview, I believe, that the thing he's most afraid of is not really Guantanamo, to my surprise, or charges or death sentence or whatever, but the possibility that whatever he revealed will have no consequences. This sentence made me personally extremely engaged in this whole process. How satisfied do you think he is at this point in time with the process of the consequences, so to say, and so far? And as a lawyer, what do you think about the personal future of Mr. Snowden? what is going to happen to him, and are we doing enough to protect his rights?
Okay, thank you. Mr. Brons.
Yes, the EU itself isn't beyond criticism as far as the war against whistleblowers is concerned. It's claimed that employees have protection under the staff regulations of officials 2004, but it didn't do much to protect the job of Marta Andreasen, who was employed as chief accountant by the Commission, but sacked for whistleblowing in the very same year. Indeed, not content with sacking her, when she became a member of this House, her appointment as Vice President of the Budget Committee was blocked. The case of an ex-MEP, I can't name him, I'm afraid, is even more sinister. He wrote a book earlier this year about financial irregularities of the EU, and mentioning that he'd received information from EU whistleblowers. Within weeks, his house was raided by the police. The raid was completely illegal because he wasn't told the purpose of the search, and they took away his computer and mobile phone. Thank you.
Thank you, Mrs. Sippel.
I'll try and keep it brief. There is no organised intent or conspiracy, but the impression is arising that various organisations, in particular secret services, are serving their own agenda in recent years. They've secured money and influence, and they're trying to hang on to that position and defend it and extend it as far as they can. And governments are finding it difficult to act against that unless, and this is a notion, they are co-authors, they share responsibility in this, and perhaps through doing nothing or not reacting, at least they've made themselves responsible for the situation. If that's a possible thesis, then I wonder how successful it can be if those governments and legislators now try and put provisions to protect whistleblowers on the statute books, when that's the sort of thing we need in this situation.
Will be the last one, in particular to Mrs. Radack. You spoke about the harassment of whistleblowers, journalists, their families, friends, what have you. What about lawyers? Is there a war on lawyers who represent whistleblowers? Do you feel that you can do your work freely and safely? Can I ask you to answer the questions first, and then I'll come to Mr. Levitt?
Sure. I don't feel like I can do my work in a normal way that a lawyer would. I mean, I feel free and safe in terms of I haven't been subject, to my knowledge, to the kind of monitoring some of the lawyers at Guantanamo Bay have been. But certainly I cannot, my clients can't just pick up the phone and call me. We have to meet in person, use throwaway cell phones, only communicate through encryption, pay in cash. I always joke that I use drug dealer tactics now to do my business. But seriously, the fact that I have to worry about that makes my work on a daily basis take so much longer than it should, and completely changes my interaction with a normal client and a normal attorney-client relationship.
Okay, thank you very much. Is there any of the other questions you would like to react to?
In terms of solutions, I think what you need is meaningful whistleblower reform. Now, with the Whistleblower Protection Enhancement Act, there have been some reforms that help a lot of other categories of whistleblowers who are not national security or intelligence community, in terms of giving them some sort of enforcement mechanism that will allow them to bring an independent cause of action. The problem, again, is that national security and intelligence whistleblowers are specifically excluded. This touches on another question where someone brought up Public Policy Directive number 19, which the President said in his speech would have protected Mr. Snowden. That is completely false. That directive is not in effect yet, and it does not apply to contractors. I think the press right now seems to be the only way to go. But again, I think if we have channels working the way they're supposed to, then that is an avenue, as evidenced today by the fact that Mr. Snowden was willing to go through an official channel and address an official government body and talk to a government body when they are functioning the way they are supposed to. In terms of how satisfied is Snowden with the state of changes, in his own words, he said that he is glad a conversation has begun about reforms and about how to change this situation. Initially, in his initial statement, he had said one of the biggest regrets would be if nothing happened. In other words, apathy. So I think by having hearings like the one you are today, the series of 12 hearings that your committee is having, gives me great hope, and I think all whistleblowers great hope. In terms of his future, that depends on the willingness of the superpowers of the world to recognize that he has been granted asylum, meaning numerous countries have found that he has a valid fear of political persecution based on his political opinions. Therefore, he does not need to answer to pretextual criminal charges. A number of people throughout history who have been granted asylum have been under criminal process of their home persecuting nation. Right now, he is granted asylum, just like Julian Assange, and yet is not living freely. And I think we need to reach a point, and I think Europe, and I think the rest of the world, in fact, is way ahead of the United States, where opinion is divided about 60%, 40%, in terms of seeing him as a whistleblower and not a traitor. In general, I don't think those labels are helpful. I think they're too binary, and we're just trying to slap labels and caricatures on people. Rather, look at the substance of what he disclosed and what it has done for the public debate and for the good of our country and for our world.
Just very quickly, not because I want to make this meeting any longer, and we've already overrun our time, but if you could make that last point more explicit, following the question of Mrs. Ernst, if he used all the official channels at his disposal, would it then be automatic that he's charged with criminal offences, or that the terrorism laws or espionage laws are applied? Is that...
That's absolutely true. If he had gone through official channels, I can tell you firsthand that I represented Thomas Drake, from whom you heard earlier, an NSA official who went to the NSA General Counsel, the Department of Defense Inspector General, and to two bodies, both houses of Congress, and made disclosures. Not only did nothing happen, the Department of Defense actually substantiated his concerns, but then immediately classified the report so no one could see it, and then later gave the name of Thomas and 4 other whistleblowers to the Justice Department for prosecution. In other words, the people it was supposed to protect, it completely sold down the river. So if Mr. Snowden, who did study the case of Thomas Drake and William Binney and Chelsea Manning, and saw that going through proper channels would result certainly in espionage charges, which have in fact been levied against him.
Okay, thank you very much, Mr. David.
I think there were 4 questions. I was asked, or we were asked, what provisions could be provided in law to protect intelligence whistleblowers. Firstly, they need to be afforded the right to defend themselves in court. They need the right to not be dismissed or harassed like any other worker, any right enjoyed by a worker protected by whistleblower legislation. They need to be afforded the right against criminal, a defence against criminal and civil prosecution where they have reported according to the law. And the new Protected Disclosures Bill in Ireland provides for these safeguards. It provides for immunity against civil and criminal prosecutions so long as they followed the law. It should also provide, I think it's important that whistleblowers know that the information that they provide will be acted upon. According to numerous bodies of research, one of the leading deterrents, one of the primary deterrents against whistleblowers or whistleblowing, one of the key reasons why people don't come forward is the belief that nothing will be done. And there needs to be a legal duty on those who receive information to act on that information. Mr. Voss asked, should information be passed on internally and should it be dealt with by employers? Absolutely. And in the UK and Ireland, as elsewhere around the world, in New Zealand and in South Africa, there is there's provision for encouraging workers to report internally. They're expected to report to their line manager or to the employer unless there is a good reason not to do so, unless there's a public interest in going outside the organisation, either to their Member of Parliament, to a regulator or to the media. Ms Ernst asked, are whistleblowers traitors? Again, I know it's a rhetorical question, but I agree entirely with Jesselyn. I don't think these labels, either heroes or traitors, are particularly helpful. But to a large degree, I think it depends on who's setting the narrative. I know this is a rhetorical question. This is not a statement you were
Juristisch, in juristical way. In juristical way. Ich möchte gerne wissen, in juristischer.
In a legal way, how's that going to be arranged? Legally speaking, how is the whistleblower going to be seen? Is it going to be seen as a traitor to the state? On what basis? On what legal basis?
Sorry, I was going to say it really depends on who is setting the narrative. And we need to tell the stories of whistleblowers. We need to stand up for whistleblowers, and whistleblowers need legal protection. Finally, I'd also point out that whistleblowers in international interregional organisations need protection every bit as much as whistleblowers in national institutions. And I know there was another question. I'm sorry, Ms. Sybil.
The question is if you really can be sure that action will be taken by governments to protect whistleblowers, especially in the case of secret services, because they may be involved or are not willing to open what is happening.
I think to a large degree that depends on the level of public demand for this. If politicians don't see this as a priority, they're not going to legislate for it.
Okay, thank you very much. I would like to first thank all our speakers today. Thank you for coming here and giving evidence. Secondly, I would like to thank the interpreters for staying longer. And thirdly, I would like to thank the audience for being so patient and staying until the end. That concludes today's session. Thank you and see you next time.